and welcome to Immigration and You. My name is Nicholas Dimitrakopoulos of Canada Direct Immigration Services Incorporated, and I would like to discuss with you today a few recent changes to the Immigration Act that were discussed prior to this on the radio. I did that about a year or two ago, year and a half, and also I wrote a newspaper article about this topic, and I would like to present it to you at this point over the web. It's about Bill C-50. Once again, my name is Nicholas Dimitrakopoulos. I'm the President, Senior Consultant here at Canada Direct Immigration Services Incorporated. I am a certified licensed immigration consultant. I would like to discuss with you the Conservative government's changes to the Canadian immigration system. These changes to the Immigration and Refugee Protection Act are contained in Bill C-50. As most of us already know, Canada's immigration system has a number of shortfalls, most obvious of which is the current backlog of applications. By making certain changes to this act, under Bill C-50, the Conservative government is hoping to solve some of these problems. Once it is adopted, which it already has, into legislation, Bill C-50 will only apply to immigration applications made after February 27, 2008. One of the concerns that the Conservative government has is that the current immigration backlog, which is close to 925,000 unprocessed cases worldwide, but yet Bill C-50 does nothing to directly deal with this growing number. What it actually does is promote the unfair processing of applications. Since 2006, we have seen an increase in the processing times, while at the same time we have seen an overall decrease in the number of new immigrants allowed into Canada. Prior to these changes, Immigration Canada dealt with applications and cases as they were received. Under Bill C-50, the priorities will constantly be changing depending on the demands which are really established by the Minister. In other words, new cases which are considered important or a priority to the Minister will be dealt with quickly, while the others will essentially be forgotten and neglected. It should be noted that currently if somebody has an application rejected, they do have a right to appeal this decision. But once again, under the new Bill C-50, the Conservative government feels that the right thing to do is to eliminate their right to appeal. By doing this, the Harper government is removing the fairness and justice that one would expect a government department in Canada to have. It is very important to note that in dealing with Canada's future and making changes to the Immigration Act, the Canadian government is obligated to present the bill before the Standing Committee of Citizenship and Immigration in order for it to be debated and discussed. The government was able to circumvent the role of the Standing Committee on Citizenship and Immigration in this particular case by burying Bill C-50 within the 136-page Budget Implementation Bill. By doing this, they were able to fundamentally sneak in these changes while not proposing them to Parliament. By tying them into the budget, the opposition parties were forced to accept them or call an election. Although the government claims that these changes will not have an effect on family reunifications, in reality, there will be a serious impact on this category since resources will be reallocated to deal with the current backlog. The current processing times in our hemisphere are among the shortest in the world. So how do they propose to help these people who have had a long-standing tradition of making Canada their home by pushing through these changes? One can't help to wonder what the motives of the Harper government are. For example, one of these proposed changes will allow the Minister to issue instructions setting quotas on the category of persons that can enter Canada, including quotas on the category of persons that can enter Canada based on country of origin. This bears a striking resemblance to the Order in Council of 1911, which prohibited the landing of, and I quote, any immigrant belonging to the Negro race. In the Chinese Exclusion Act of 1923, any immigrant of any Asiatic race was excluded. And more recently, the none is too many rule was applied to people fleeing Nazi-occupied Europe during the Second World War. Giving the minister the power to decide which new immigrants are processed regardless of when their applications are filed is extremely dehumanizing, since it will be based on their ability to satisfy the needs of the Canadian job market. In essence, what we are doing is viewing immigrants as disposable commodities. Even though the government insists that these changes are necessary for us to modernize our immigration system, other high-ranking officials have stated that the government is seeking to create a competitive immigration system which will quickly process skilled immigrants who can make an immediate contribution to the Canadian economy. Ever since 9/11, time and time again, we have seen the government make decisions to allocate funding and tools towards more repressive measures. For example, more than $100 million has been dedicated to arm our Canadian border guards, and their priority has slowly shifted to one of an enforcement agency with regards to processing refugee claims, while at the same time sending out the message that refugee claims are a threat to public safety. Also, the use of safety certificates against non-citizens and the implementation of the Safe Third Country Agreement between Canada and the US has drastically reduced the number of asylum seekers able to make claims in Canada, while at the same time increased the deportation rates to over 13,000 a year. This shift in Canada's immigration policy has perpetuated a racist, anti-poor, and anti-migrant agenda. In my professional opinion, which is shared by a majority of lawyers, immigration practitioners, and immigration non-governmental organizations, including the general public, is that before any changes can be made, we need to fully assess the implications and possibly look for alternative solutions in order to address the current backlog. I believe this can be accomplished by hiring more staff to deal with cases inland and overseas, and possibly streamlining the process so as to make it quicker and easier for applicants to complete the process. I believe that Bill C-50 as it stands needs to be seriously revised. People should write to their local MP, let them know how they feel about Bill C-50. A number of local organizations have joined together to object to these changes. It is important that if we are to protect everything that we love about Canada, then we must stand up and be heard. Up to now, the Harper government has been very secretive about these changes, and whenever they are questioned, they've made a number of statements about what their intentions are. The sad truth is that expressions of current intentions gives us no guarantee against future abuses of this power. After all, why are the immigration amendments included in the budget bill instead of being dealt with through separate legislation, studied by the Standing Committee on Citizenship and Immigration, and debated in public the way they should have been? Combine this with the lack of adequate information explaining the proposed changes, and what we have is widespread confusion and uncertainty. Instead of providing us with clear supporting materials, the minister chooses to attack critics of the amendments and claiming that we are misinformed. Even to this day, it is difficult for the public to understand what the government is proposing to do, and since the draft instructions have not been made public. Perhaps most importantly, these proposed amendments were introduced without the normal consultation of stakeholders, which is the normal protocol. Means that the proposal has not had the benefit of being discussed with a wide range of perspectives. In fact, even though the main purpose of these changes is to help resolve the existing backlog, I doubt that this will be accomplished, since it's only going to affect applications made after February 27, 2008. Finally, I have to say that these changes seem to be contributing towards the distributing shift that immigration is used to meet Canadian employer needs without taking into consideration Canada's long-standing immigration, multicultural, and humanitarian policy. We should not rely so much on temporary workers and instead consider our workers as full participants in our society, not just disposable units that are here to fill current available jobs. We need to recognize the need for effective and efficient family reunification policies and practices so that the immigrants can be with their families. Yet the government, with all its promises and intentions, is not addressing this chronic problem. That's all for today's commentary. I'm Nicholas Dimitrikopoulos of iCanada Direct Immigration Services. Like I said, this article was written a while back, so some of the things we've already seen come to fruition, and in my opinion, what I wrote then still applies today. Get out there, write to your MPs, make a change. Bill C-50 is not the way Canada's immigration policy should be heading. Do something about it. iCanada Direct, feel free to get in contact with us. 647-435-3315, or you can email us info@icanadadirect.com. Until next time, Immigration and You is now adjourned.